Florida Family Court is what's called a court of equity. When you're researching your family court case and determining your strategy for litigation, you're looking at the procedural rules, the Florida statutes, and the case law that relates to your jurisdiction. But there is a not so secret fourth thing that the court has to consider in all family law cases, which is equity or fairness. And there are some very rare situations where you can make an equity argument that isn't contrary to the law, but isn't maybe supported in case law. You can't find an example that says the court has done this in the past, but you can explain that it's not contrary to the law and it is fair and equitable in these circumstances. There are legal presumptions that function in family law as baseline starting assumptions the court has to start with to determine how to rule on things. The presumption for equitable distribution is that everything should be split 50-50. But these presumptions are rebuttable. If you can prove that in your circumstances, a 50-50 split is not fair and equitable, you can ask for an unequal distribution of marital assets and debt. One time I litigated a divorce case where the presumptions and the statutes and everything, the case law, all supported the fact that there was a marital home and that it should be sold and the proceeds should be split 50-50. However, it was a very short marriage, and the opposing party had clearly abused my client throughout the entirety of their very short term marriage. My client had an inheritance entering the marriage. They put that inheritance into the home that the parties purchased during the marriage. My client wanted to keep that home. It was debt free. It was their home that they purchased with their inheritance money. And they didn't realize that they were commingling it by putting the other spouse's name on it and that they were losing the right to their inheritance, right? And so it just wasn't fair. It wasn't equitable. So I did a lot of research, I did a lot of preparation, and we came into court and we made an equity argument. And opposing counsel came into court and made a legal argument. Look, it's 50-50. Everything's marital. It should be split. I went in and demonstrated to the court that in this specific situation, that 50-50 split, that presumption is inequitable. It is completely unfair given the circumstances of this case. And guess what? We won. My client got to keep the home, and the other spouse didn't get anything from it because it wasn't fair and equitable. Now, I don't want to give you false hope. I don't want to tell you that you can go into court and win your case on an equity argument no matter what. It is very difficult to do. It usually requires an attorney. You can try it if you're pro se. I just want to make sure everybody understands that there is the law, there is case law, there's presumptions, and in Florida Family Court, there's always an equity argument to rebut a presumption that is unfair to apply in your situation.